Council, there's no application.
There's not, Judge.
Okay.
Good afternoon.
Good afternoon. All right. Court is calling 2024 CR 012217 State versus Jorge Alberto Guevara. Can I have parties announced?
Jeffrey Art for the state.
Orlando Castañon for defense.
And are you Mr. Guevara?
Okay.
Yes, is that you?
Yes, ma'am. I'm sorry.
All right, no problem. I'm sure I'm probably mispronouncing it. I'm sorry. Counsel, have you received all discovery?
Yes, Judge.
Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Guevara, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented? Mr. Guevara, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand your charge with online solicitation of a minor for sexual conduct?
Yes, ma'am.
That's a second-degree felony.
Yes.
Range of punishment is anywhere from 2 to 20 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Guevara, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
100%.
All right, if you're not a US citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to a jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 3 years. I know that it was a cap of 5, but there's a line drawn through that. So you all are proceeding with a sentence of 3 years.
Yes, Judge.
Right, there's $1,000 fine, no applications, and Chapter 62 compliance. Did you understand that to be the plea?
Yes, ma'am.
Defense,
Yes, Judge.
state,
Yes, Judge.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motion?
No, Judge.
Then to the offense as charged, how do you plead?
Guilty.
State, any evidence?
Not for state exhibit 1 and attachments.
No objection, Judge.
All right. Did you review the waiver and consent to stipulations of testimony and stipulation with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And state, you may be excused unless there's another matter.
I can just stay here, Judge. It's my only case.
Okay. People
So no
love being
question.
in the 187. I like it. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
All right, why should I follow this plea?
Judge, he has no prior criminal history. He's accepting responsibility. We've discussed some defenses to this case, but in light of I think all the facts, I believe that he thought this is in his best interest to pursue, and as such, we're asking you to follow this agreement.
What were you thinking?
I wasn't thinking,
And how old are you?
34. I was going through rough times. Started an excuse, undefendable.
No, and let me just tell you something.
Yes, ma'am.
So obviously, if this were an actual child on the other end of the line, you were trying to take advantage of them, right? And I'm just telling you, you cannot build your happiness off somebody else's misery. And if that were a child, and if you were to actually have met that child,
No, yeah.
You understand?
Yes, ma'am.
all right, the court is going to find you guilty, sentence you to 3 years in the prison. There's $1,000 fine. Chapter 62 compliance. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal because this is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
Counsel, they always say, if somebody says, yes, 100%, that means they're telling the truth. If you ever watch Maury Povich, when they're saying you're not the
Wow.
father, whenever somebody says, I'm 1,000% sure, anytime they go over 100%, it's not true. So he really meant that when he said 100% satisfied.
Thank you, ma'am.
All right, thank you.
Yes, ma'am.
Oh, thank you, you too.
Ray Mauer for Mr. Lopez.
And are you Mr. Lopez?
Yes, ma'am.
Counsel, have you received all discovery and did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state has to wait the enhancement out.
We have no objections.
All right. Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with theft of property less than $2,500 with 2 or more convictions as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's an $800 fine. State is opposed to your applications. They're taking in consideration 2025 PF 42484. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There were not.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor, state upper state exhibit 1 and all of that.
No objections.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you requesting a PSI?
We are, Your Honor.
All right. It will be 8 to 12 weeks, or if you would like, it could be shorter. And what will end up happening, I'll just hear any witnesses you all would like to present.
I think we would prefer the shorter one. I would anticipate just having one witness, Your Honor.
All right, Ms. Abrams, this is a waiver of PSI and TAP evaluation.
Okay, Judge, thanks.
All right. Ms. Ferguson?
I'm sorry, Your Honor, I misunderstood. So that means that you would not do the PSI. It would just, okay, I apologize. I think we, let me kind of take a step back
Sure.
and go for my client real quick.
Okay. What page is Lopez on?
I can look at that.
Thank you.
Up one from the phone?
Yes,
I can also mark page 2, 3, 4, 5.
all right, thank you.
Yes, ma'am.
Oh, I don't know.
Yes, sure. All right, thank you. All right, yes.
Your Honor, I believe we will waive the PSI and just present the one witness when we come back.
All right, how much time are you requesting, counsel?
As far as when we come back,
It would have to be in December.
maybe that first week of December, Your Honor, or second week of December.
All right, Ms. Ferguson. All right, I'll give you your date. All right, do you prefer the first week or the second week?
The second week, just so I can ensure that I can get my witness down here, Your Honor.
All right, so it can be the 8th, the 9th, or the 11th.
The 9th works for me, Your Honor.
All right, so we'll come back on December 9th. At that time, I'll make a decision on your requests based upon any evidence that's presented to the court, okay?
Yes.
All right, thank you.
Thank you, Your Honor. May I present the rejection to the
Yeah.
case?
There you go.
Judge,
You're welcome.
maybe excused.
Yes,
Judge, what would that be?
December 9th.
And that's what's gonna be for sentencing, Judge?
Yes.
Thank you.
659, State versus David Allen Hernandez. Could I have parties announced?
Those are for the state.
Ryan Arnett for Mr. Hernandez.
And are you Mr. Hernandez? And counsel, you ready to proceed on the motion?
Yes, Judge.
All right, Mr. Hernandez, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same David Allen Hernandez who was placed on community supervision in 2024 CR 009659 for the offense of possession of a controlled substance, penalty group 1 to 4 grams, on November 21st, 2024, for a term of 10 years? Is that you? All right, state.
Violated condition number 4 in Bexar County, Texas, the defendant David Allen Hernandez did then and there fail to report to the supervision officer as directed for the months of May, June, and July 2025 in violation of condition number 4.
Just one moment. I need a box there. For a motion to revoke. To that, how do you plead? True or not true? I'm sorry?
True.
State will waive the remaining violations.
Any objections to the state's waivers?
No objections.
All right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 10 years in the prison and up to a $2,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
Yeah.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to deny state's motion, continue on probation, but alter and amend conditions for state ISS on the track.
And what is occurring with the new number 1s that are in the document?
So the new number 1 we engaging is not active with our office, but this act is being rush filed so that we need to.
All right. So, Mr. Hernandez, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
David Allen Hernandez.
Why didn't you report?
Me and my girl fell on bad times. She got pregnant. I was really dealing with that situation. I was my probation. Then we were kind of out. Lost our spot. We were standing in the vehicle. Our vehicle, 2 other kids. And that's really why I just started focusing more on the babies than the report.
All right, and where has that?
She's got an apartment now.
No. I mean, the fact that you were focusing on the children, which I don't know if that's true or not, I'm just listening to what you're saying. So what did that accomplish by not reporting? And so it appears that she's able to function without you, because how long have you been in custody?
3.5 months.
3.5 months. So she's been able to get a place without you, a place for the children without you. And are these your biological children? All right, so I don't understand why you should be continued, because You've pled true to not reporting for the months of May, June, and July of 2025. And we are here almost in December. So there are a lot of months that you didn't report. So what have you done since you've been on probation?
Stayed away from drugs. What I, this is on probation for, I went to that lot of my recovery. That was,
Did you complete lifetime recovery successfully? Probation,
Yes, Judge.
what are you recommending?
In our initial conversation, I recommended, what the ADA and defense counsel has. On the court summary, they wanted to, alter him in for status.
So my problem to both parties, I don't know if he's been clean or sober or not, because he hasn't reported.
Yes, Judge, I understand. And if necessary, he could undergo a new type evaluation. And if substance abuse is what the court deems necessary, then we understand that. We just thought ISF cognitive would be more appropriate in this case because we thought it stemmed from maybe not being in the greatest spot in his life, but not understanding how to make the decisions to prevent being in those spots and how to come out of those spots without any sort of harmful thinking to either himself or others.
But that's what lifetime recovery teaches you. When you're in the sober support meetings, that's what they teach you to make better decisions. I don't think he's appropriate for probation. He's been gone. So, yes,
I believe that he would be a good candidate for probation. I think that it's not that he made a mistake, he made a decision and it was a bad decision. And he's now here on this MTR. He understands the gravity of not reporting. It's not as simple as just not reporting and continuing on probation. He understands that he must be reporting as directed by the probation department. He's willing to undergo the ISF cognitive for 90 days inpatient to correct his thinking to continue to be a good candidate for probation. And he is really looking forward to correcting his own behaviors for his future children. As he said, his girlfriend is currently pregnant with twins. Those will be his biological children. And then also the two children that he takes care of that are not his biological children.
how old are you?
21,
So you should know you need to report.
yes.
And so here's my question. Were you arrested or did you turn yourself in? Where?
Leaving a restaurant, taco restaurant, getting taco.
Probation, do you think he would do well to be continued or no?
Judge. I'd say let's give him a chance. And he doesn't report or if upon the first infraction, we file a motion to revoke.
All right, here's the thing. I'm going to give you two choices. You only have two choices. There isn't a third. Don't ask for a third. I can revoke you. I'll sentence you to 3 years in the prison. You'll get credit for any successful inpatient treatment because legally I'm required to give that. Or I can continue you and you're going to ISF. Which do you prefer?
I'll take the ISF for try to see my kid for.
Oh, so here's the thing. I don't know what the wait time is for ISF, but you will be in custody and be transferred. All right, the court will deny the motion. Alter and amend conditions to include ISF cognitive. Is that the local one, Ms. Abrams, or no? Okay. Is there anything else he needs? Is there anything else you need from the court to be successful?
Yeah. I need help with that. I really need help.
Help with what?
I'm thinking about how they set up Kentucky.
And then Judge, just for the record, when he was saying that, I was just talking to him. Whenever I was appointed, it was notified on the appointment letter that he was homeless. He would like to be recommended for any housing services as well to help him with housing going forward.
All right, upon release, resources for housing and employment. And the court previously required parenting classes. You need to make sure you complete those. Do you understand? All right, we can go off the record. Here's the thing. You better make sure that you report. Do you understand? Because being on probation doesn't mean I'm on probation. I won't commit any new offenses, so it's all fine. That only works usually for municipal court with tickets. You understand? All right, good luck to you. You're welcome.
And then Judge, do you know if those parenting classes, can they be completed in ISF or?
You'll have to speak to
Okay.
probation
Right.
because sometimes those classes are transitional there, which
Yeah.
ones they have.
Okay,
Alan, and am I going to be seeing you tomorrow
No, Judge.
for mental health? It'll be Christine.
Correct, Judge.
Okay. All right. What are we here for?
Motion to revoke probation, Judge.
And are you all ready to proceed on the motion?
Judge, I do think we have, so Melissa was the one that conferred on this, but I believe the parties had contemplated having a TAP evaluation done in the MIT while in custody, and then depending on those results, we see how we move forward. I don't know.
That's what we're more so thinking, Judge. But in the interest of expediting this matter, my client feels comfortable completing true with the hopes of treatments, and then having the TAP mental health evaluation in custody, and whatever the recommendation is by the professionals doing those exams, that the court may order that.
All right. Court is calling 2025 CR 003825 and 2025 CR 003824. State versus Christopher Anthony Mazuka Garcia. Could I have parties announced for the record for the state?
Lauren Espinoza for the state.
For the defense?
Renee Munoz on behalf of Mr. Masuko Garcia.
And are you Mr. Mazuka Garcia?
Yes, Your Honor.
Did you review the documents in each of those cause number entitled motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And in the cause number ending in 24, are you the same Christopher Anthony Mazuka Garcia who's placed on deferred adjudication in 2025 CR 003824 for the offense of assault peace officer judge on July 8th, 2025 for a period of 3 years?
And it was an attempted attempt to commit peace officer judge, I believe.
All right, so this is incorrect. All right, the motions to revoke the charge is incorrect. And let me see. And it's in each motion, it's not listed appropriately. Are there any motions to change assault peace officer to attempted assault? Any
No.
objection?
No objection, Your Honor.
All right, so in each of the cause numbers, 2025 CR 003825 and 2025 CR 003824. Are you the same Christopher Anthony Mazuka Garcia who was placed on deferred adjudication for the offense of attempted assault of a peace officer or judge on July 8th, 2025 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state. And are you proceeding on the same violation in each cause number? All right, you may proceed.
Violated condition number 4 in Bear County, Texas, the defendant Christopher Anthony Bezuka Garcia did then and there fail to report to the supervision officer as directed for the months of August and September 2025 in violation of condition number 4.
And how do you plead to true, how do you plead to that in each motion?
Your Honor.
Violated condition number 4 in Bear County, Texas, the defendant Christopher Anthony Bezuka Garcia did then and there failed to report to the supervision officer as directed for the month of October 2025 in violation of condition number 4.
How do you plead to that?
True, Your Honor.
And that's true in each motion?
Yes.
Is that true in each motion?
Yes.
All right,
State will waive the remaining.
any objections?
No objection, Judge.
All right, in each cause number, did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison in each cause number and up to $10,000 fine?
That's fine.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes, Your Honor.
In each motion, the court will find violations 4 and 4 true. Is there a proposed agreement?
Yes, but the recommended agreement from the parties is to deny state's motion, alter and amend to add conditions at the top with this. Continue on probation, and then we will TIC the new burglary of the building and then have the misdemeanor.
Okay.
That is our understanding as well, Judge.
And what is the felony?
The number is going to be 2025 PF 43911.
And counsel, the misdemeanor, when will that be taken care of?
We can get that taken care of by next week, Judge. I think
Okay.
by tomorrow will probably be a little bit late notice, but next week we'll be able to next week's Thanksgiving.
Mhm.
I believe, Judge, just to say confidently, I think the week after Thanksgiving, that week of December, the first week of December, we can definitely get that in.
All right, and probation, is this your recommendation?
Yes, Judge.
All right, do you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
It's Christopher Anthony Bezuka Garcia.
All right, and where have you been? Why haven't you been reporting?
My grandpa died and I got into a tough time. My mom got cancer. She went to the hospital and it became too much for me to be at home alone with my dad.
Hmm.
We got into an altercation and so I removed myself from the situation, given that I had assault charges. I didn't want to end up it, so I had been staying with a friend, but only like at night, not during the day or anything. During the day he goes to work, so I wasn't able to be there. So I was with my girlfriend, really just around in the streets, not really doing much. We spent a lot of time at the park, just just talking about our future, what we wanted to do. I was actually doing really good. I had already started employment. I was helping out right now, doing lawns. We were mowing lawns and we already had started doing so she was going to the NNA meetings and I was starting to join her out of volunteer because I knew I was supposed to be going to something, but I didn't understand how to get to where I needed to go or how I was gonna go about trying to do my probation. I went to my orientation, but upon leaving my parents' house, I lost my paperwork. I was just confused and scared of what to do. I thought I was gonna go back to jail immediately as soon as I went in. I know I didn't go about it the right way. I just want help. I want to get back on the right track again. I want to get back to work and I want to get back to my girl. I have substance abuse issues.
We both been, I've been working on it and she's been a rock with me on that, like we've been pushing each other further and further. I fully want to stop using completely. I don't want that to be a part of my life or my future. I know I'm changing from a boy to a man and I'm trying my hardest. I really just want to help more.
Okay. All right, this is what the court will do. The court will follow your agreement, deny the motion, alter and amend conditions, take into consideration 2025 PF 43911. There's to be TAP evaluation in custody, follow the recommendations, mental health evaluation. And let's do a referral to felony drug court. I know they're at capacity, but at some point in time, maybe they'll have room for him.
Judge, do you want that felony drug court eval to be completed after the tap?
Yes.
That's what the felony drug court is.
The felony drug court is a program. It's very intensive, but it'll help you if there's mental health issues. It will help you with housing. It'll help you with employment, and it'll help you with any type of drug addictions. Okay.
Thank you.
You're welcome. So there's to be no residing in households with minors. And probation, if you can help him with resources for employment and housing. Is there anything else that you need?
I wanna. Already can help doing, no, I think you're thorough with what you're doing for me. Thank you, Your Honor.
Okay, so here's we can go off the record. Here's the thing about this court. When you're on probation, one of the worst things that you can do is just disappear. If you have an issue, just let probation know about it. If they feel like they're not addressing it,
How would I do that if I?
they have contact information for you. If for some reason you can't get in contact with him, that with him or her, you can always come back to the court. I'm always here.
So I would just come to this courthouse and then.
Yes,
say-
but first, you need to try getting in contact with your probation officer, okay? But coming to the courthouse,
'Cause I don't even know who my probation officer is.
all right, they're gonna make sure you know. And here's the other thing. We're only here Monday through Fridays, okay? Saturday, Sunday, I'm not here. If I'm here on Saturday or Sunday, that's not good.
You're working too hard at that point, Judge.
Yes.
No, you are a very hardworking judge.
All right, thank you. Is there anything else?
Nothing further, Your Honor. Thank you for being so thorough, for allowing him this opportunity.
All right, good luck to you.
May I tender this dismissal?
Yes. Let me put this in the system. All right, today is plea deadline date. Have you all reached an agreement, or is this gonna be a jury trial?
It's gonna be a jury.
How long do y'all expect this to last? Norma, I need a jury trial date, 3 days.
Yes,
Sure.
since the day I got arrested, I was whisked away in the cop car. I spent 4 months in jail, not talking to anybody. I barely spoke with my lawyer, but twice, less than 25 words, both court dates. I've seen him talk to the district attorney. Even less words than that.
Mhm.
So I just want to be heard, Your Honor, that it was a self-defense case.
No, let me stop you right there.
Okay.
So with regards to your, no. Here's the thing, with regards to self-defense. You're charged, according to this, with assault, family violence, choking. Yes. So with your attorney and his conversations with the state, maybe he's received all the information he needs to receive from them. For him to say that you're requesting a jury trial means that an offer has been tendered and you've made the decision that you do not want to accept the state's offer, and there is no agreement that's been reached. Is that correct? I don't want to know what the offer is. My only question is,
I just want to be heard, Your Honor.
Oh.
That,
could you tender him the offer, please?
yes.
So he's gonna continue to offer, then you can let me know whether or not you have accepted the offer.
mind going to trial. I'm very confident that.
All
I
right,
will-
then we're gonna give you a jury trial date.
I just. Thank you. I just wanted to be heard that. I think I would be better off in probation, not because I think I'm guilty, but because.
But let me ask you this, so, and let me explain something to you. Number one, what you've been in charged with, and I don't know anything about your case, the only thing I know is what's in the indictment. Wait a minute. All I know is what's in the indictment. What's in the indictment is they're charging you with assault, choking. Now, normally assault, choking, family is a 3rd-degree felony. They're proceeding on you as a 2nd degree. So that means that they're saying that there's something else that they're alleged that's in your past. Either what's in your past is another family violence case, or either they're enhancing you because you've been to prison before, right? Now, with regards to making this a 2nd degree instead of a 3rd degree, if there's a jury trial, or if the state has to prove that, your attorney probably has already told you that's proved with documents. Whatever that case is, there is normally not a retry of that case. For example, if somebody's been to prison and the state wants to use the fact that they've been to prison to bump up their range of punishment, that case doesn't get retried. All they do is bring in what's called a pen packet. They present it to the jury and they have to prove that that pen packet is actually yours. And they bring that to a jury. And then with the case, whatever you're on for, that's a part of the indictment that they're accusing you of. For example, with assault, family choking, of course, they need a complainant. That's the person who's saying you did this.
I called
Then
police.
they need that person, they need an on or about date, and they need somebody to say it was you. And then the jury will hear that evidence and the jury will make a decision on whether you're guilty or not guilty. Whether or not you believe you deserve probation or not, that's your belief. If you go to jury trial, if the state are able to prove what they're able to prove, and I don't know what that enhancement is or how they come by that enhancement, based upon that, you may or may not be eligible for probation from a jury. But whether or not you tell your side of the story or whatever, that depends on you. You have a right to testify or not testify. The state can't call you as a witness to testify, but it appears that you all are at an impasse. It appears that you want probation. It appears the state is not offering probation. So your plea deadline date has expired and you will be set for jury trial. And you all think this will last 3 days? Ms. Ferguson, I need a 3-day setting for a jury trial, and counsel, if you'll do acknowledgement of discovery. Judge, it could be February 24th. I need it in January. I can do January 13th. You say 13th? All right, your jury trial date is going to be January 13th. You're going to be brought over in whatever civilian clothing you have at the jail. If you wish to be attired in something different, there'll have to be a clothing exchange. Counselor, the new rules at the jail is that the clothing exchange must be requested within 72 hours of trial. So you can't do it 2 months in advance, or you can't do this in December. It'll have to be exactly 72 hours.
I have to request this clothing?
If he wants to do a clothing exchange, you have to file it.
Yeah, I mean, my shorts are torn because my son pushed me through.
Oh, okay.
Okay. All right, thank you. Who's next? All right, and counsel, on this case, are you going to want a PSI report?
Yes, Your Honor.
All right, I need a date for PSI and TAP.
January 13th.
All right. Court is calling 2025 CR 0068882, State versus Matthew Stephen Martinez. Can I have parties announced?
In Galloway for the state.
Romal Rota representing Mr. Martinez, Your Honor.
And are you Mr. Martinez?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
yes, yeah.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Any objections?
No, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand in count two, you're charged with assault on a peace officer? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, or reentry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $2,000 fine. The state opposes your application for community supervision or deferred adjudication. There's to be restitution to the complainant, if any, and the state is proceeding on count 2. Did you understand that to be the plea?
Yes.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes. Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Did offer to state.
I have no objections, Your
All
Honor.
right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Question?
All right, after reviewing States Exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. This will come back for a TAP evaluation on January 13th, 2016. I'm sorry, 2026. I will base my decision on your application on the PSI and whatever evidence is presented. Do you understand? Do you have any questions about anything?
No.
All right, probation is gonna give you instructions. Make sure you meet all of those appointments because there's an appointment with your probation officer. Then there's a separate appointment that's usually scheduled for TAP evaluation, okay?
Yes.
All right, so make sure you sign the reset form and speak with probation before you leave.
Thank
Thank
Judge.
you.
May I be excused?
Yes. Who else is next? I have never had COVID. I'm not trying to get COVID. Well, you know what? Let me reverse that because people always want to know who patient 0 is and hey, maybe we want to do something to figure out what's in their blood. So I've had COVID several times. All right, this is final discovery.
All righty. Judge, I've got all the discovery I need. I need due diligence. We're close to resolution to the case.
Mhm.
So we just need one more setting, Your Honor.
All right. Norma, if you can set this for 30 days for a plea deadline date. All right, December 18th.
All right, Judge.
All right, thank you. How old are you?
18.
All right, be sure to stay in contact with your attorney.